Bill Van He's in the military. So I had a couple of years at West Point.
I think that's good for
Engineers.
Join in.
What more than this?
How are you? Ethan, Chris Gold.
John, good morning. Dwight, where are you guys from?
We drove up from Colorado.
Yeah.
I work for Sugar
Down my
Oh, yeah.
and Dwight's my bona fide mentor. We run radio stations, publishing internet, conservative Christian media.
99 stations in the United States. He's got 3 in Colorado Springs.
The only one we have is Mark Claudette. Well, I got Dennis Prager on middays. True. It's true. I don't know the answer to that. Did you read the this morning? So they're going to have to go back through the process. So just for the time being, so this issue is about the university having to recognize LGBT on campus.
I've met you a long time ago.
Very organized. Lived in like, they're not like the Amish.
It's very strict. So rules are, the men have to study the Torah 1 to 4 hours a day. But I mean, that's what they're based on. I mean, it's really downstairs. So do they get to do that in America, or are they going to be forced to be, beholden to the rules of the left? So it'll be interesting to see how that works out.
You wake up in the morning,
Tell me, so what is it that you do, sir?
My own business. International trade. People definitely follow up with you about your project.
Yeah, we have that as well.
We came from Virginia. There was 24 states here in Colorado. Legislative session. Going to get the word out, what's going on, and see if you can sign on. Go online petition, it's just ways to go.
We can have you on down in Colorado Springs, and then if you're interested in being in Denver, I can put you in touch with a couple of stations up here. KNUS, and then KRKS, which is Christian Teachers. Good morning, Miss.
Hi.
Chris School, how are you?
I'm Therese
Hey,
Frost.
Therese, you've got a very thin plate. You sure you don't want me to go back and get a little more for you?
I'm not a big fan of oh my, 10 or 11.
I understand. I'll see you when you come back. Yeah, I mean, yeah. Right here? I drove right on the way up here and picked them up. It's really not work. Just because I love what we do reaches people with the truth. exciting. You know, even amidst all this difficulty, you know, we don't need the happy warriors. You know, we really do. We're going to show that joy.
I'm sorry.
His wife, maybe now, grew up in Denver. Very close to my grandmother. The two whites were better than my name.
Oh, it's perfect.
It was funny because they were Pomona Presbyterian.
How are you?
We were all down at Central Presbyterian. So, you decide what you're going to take on. He had a ranch up in Fraser. They go up there and throw string fish together 3 times a year. Just sneak up in the country. He's sick in his heart.
We were having fun.
Yes, they can.
All right, good morning, everybody.
Good morning.
Welcome, welcome, welcome to the first annual Colorado Christian University Constitution Day celebration. It's great to have you with us. We've got a great group in this room today. We've got CCU students, faculty, staff, and administrators. Our business council is joining us. These are donors and supporters of the Centennial Institute. And then if you're just a guest from the general public or watching online, welcome as well. We're so glad you're with us. Friends, CCU is a university on a mission. We host monthly events to advance Christian conservative public policy in our culture, but this is our very first Constitution Day celebration. We're here partially because of the encouragement of both the Chancellor of CCU and our interim president. Last night, students, hosted by 1776 scholars, had a ice cream social and did Constitutional Jeopardy. So they are active on campus. Do you know a lot of colleges in America that might be having Constitution Day celebrations? Probably not, right? We're a little unique. This is the 235th anniversary of our Constitution, tomorrow actually. They originally gathered, these delegates, on May 25th, 1787, representing every state except Rhode Island. They got together in Pennsylvania's State House for the Constitutional Convention. It's now known as Independence Hall. The Constitution was signed by 39 delegates present at the conclusion of the Constitutional Convention. They ranged in age from 26, being the youngest, not much older than you guys, to 81. You guys know who was 81 years old? Benjamin Franklin. That right. The average age of a signer of the Constitution was 42. 8 had signed the Declaration of Independence. 25 had served in the Continental Congress. 15 helped draft the new state constitutions between 1776 and 1780, and 40 of them had served in the Confederation Congress between 1783 in 1787. Virtually every signer had taken part in the revolution. At least 29 had served in the Continental Forces, most of them in positions of command. All but 7 were native to the 13 colonies. But it was a hard day on June 28, 1787. They had been working for about 4 or 5 weeks, and they had run into challenges on how states were going to be represented in the legislature. Here's just kind of an actual record of what that day was like. Mr. Luther Martin of Maryland finished the speech he had started yesterday, arguing that the general government should be formed for the states and therefore they should be represented equally. Mr. Lansing of New York, seconded by Mr. Dayton of New Jersey, moved to amend the 7th resolution to read the right of suffrage in the first branch, that's the legislative branch, ought to be according to the rule established by the Confederation. 1 vote per state. Williamson of North Carolina opposed the motion. If the states were equally sovereign now and parted with equal proportions of sovereignty, they would remain equally sovereign. Madison of Virginia also opposed it. Even those of New Jersey had agreed on equal vote was unjust to the larger states. It's not much different than what you might hear in the news today. How does California have equal representation with Wyoming? Sherman of Connecticut observed that it wasn't a question of natural rights, but one of how rights may be guarded in society. The question was postponed at the request of the deputies of New York. They couldn't get past this question. So 81-year-old Benjamin Franklin rises and gives this speech. This was not a written speech. This is from his heart. Mr. President, the small progress we have made after 4 or 5 weeks, close attendance, no air conditioning, he didn't mention that, didn't exist then, continual reasoning with each other, our different sentiments on almost every question, several of the last producing as many no's as yeas, is methinks a melancholy proof of the imperfection of the human understanding. They can't figure it out. We indeed seem to feel our own want of political wisdom, since we have been running about in search of it. We have gone back to ancient histories for models of government and examined the different forms of those republics which having been formed with the seeds of their own disillusion, now no longer exist. So they're looking at all of these old governments, all the way back to Rome and Greece. They don't exist anymore. And we have viewed modern states all around Europe, but find none of their constitutions suitable to our circumstances. There's nothing out there that works. In the situation of this assembly, groping as if it were in the dark to find political truth, and scarce able to distinguish it when presented to us, how has it happened, sir, that we have not hereto once thought of humbly applying to the Father of lights to eliminate our understandings? In the beginning of this contest with Great Britain, when we were sensible of danger, we had daily prayer in this room for the divine protection. Our prayers, sir, were heard, and they were graciously answered. All of us who are engaged in the struggle must have observed frequent instances of superintending providence in our favor. We saw God's hand in every aspect of the revolution, says Benjamin Franklin. To that kind of providence we owe this happy opportunity of consulting in peace on the means of establishing our future national felicity. We're here today, we get to gather in peace to debate this, and have we now forgotten that powerful friend? Or do we imagine that we no longer need his assistance? I have lived, sir, a long time, 81 years, and the longer I live, the more convincing proofs I see of this truth, that God governs in the affairs of men, and if a sparrow cannot fall to the ground without his notice, it is probable that an empire can rise without his aid. We have been assured, sir, in the sacred writings that except the Lord build, they labor in vain that build it. I firmly believe this, and I believe that without his concurring aid, we shall succeed in this political building no bit better than the builders of Babel. We shall be divided By our little partial local interest, our projects will be confounded, and we ourselves shall become a reproach and a byword down to future age. And what is worse, mankind may hereafter, from this unfortunate instance, despair of establishing governments by human wisdom and leave it to chance, war, and conquest. I therefore beg to move that henceforth prayers imploring the assistance of heaven and its blessings on our deliberations be held in this assembly every morning before we proceed to business, and that one or more of the clergy of this city be requested to officiate in that service. They're stuck, they can't figure it out. Benjamin Franklin, the oldest and wisest among them, calls for prayer. And on this day, 300 or 235 years ago, they put what would become the world's longest surviving written charter of government in history. So, just like the delegates, we're going to begin in prayer. So please, if you can, let's stand. And leading us in prayer is Casey Jane, and then we're going to do the Pledge of Allegiance, led by Daria Nichols.
Please bow your heads with me as we pray. Dear Jesus, thank you so much for bringing us all here today safely. Thank you for John Malcolm and his wisdom that he will bestow on us today. As we remember the power of the Constitution, the faith, the wisdom, and the strength of the Founding Fathers who wrote this, we thank you for blessing this country. Thank you for this food, and bless our time together here today.
Amen.
All right, please join me in saying the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. Thank you, CCU students. You may be seated. Friends, I'm going to turn it over now to a good friend of the Centennial Institute. He's served on the Board of Trustees in Colorado Christian University for many years, and now has the role as interim president here at Colorado Christian University. Please welcome Mr. Tim McTavish.
Thank you, Jeff. Good morning, Patriots. I am Tim McTavish, CCU's interim president. I want to thank you for coming out this morning with you. I'm looking forward to today's presentation by John Malcolm. Today we celebrate a great governmental achievement in human history, the establishment of the U.S. Constitution and the rule of law, which we derive our responsibilities and freedoms. While I wish I could tell you that every university across our nation is taking time to honor the Constitution on this day, regrettably that is not so. Colorado Christian University stands among the minority. 15 years ago, former U.S. Senator and then president of CCU, Bill Armstrong, laid out for us our strategic priorities and those things for which the university would take its stand. One of these strategic priorities was that we would impact our culture in the support of traditional family values, the sanctity of life, compassion for the poor, biblical view of human nature, limited government, personal freedom, free markets, national law, and get this, the original intent of the Constitution and of Western civilization. Not every university requires courses in American history or U.S. history and Western civilization. CCU does. And we don't rewrite that history to fit a politically correct narrative. Not every university requires economics courses. CCU does. When we teach economics, we teach about free markets. We teach about the importance of personal property rights, free trade. The week after next, our students will be attending a symposium on the topic of socialism versus capitalism. Nearly every one of our 1,500 students here on campus will attend multiple sessions on the topic. If you would like to attend or learn more about that event or watch a video recording, Jeff Hunt and the team here at the Centennial Institute can get you those details. Students at CCU receive an education based on the truth of Jesus Christ, rooted in Scripture and built on the traditions of Western civilization. It was the Apostle Paul who stated that every person is subject to the governing authorities. For there is no authority except from God, and those that exist have been instituted by God. What is our governing authority as Americans? Is it the President of the United States? Our state governor? Following our ultimate governing authority of the King of Kings and Lord of Lords, and the scriptures that testify of him, I would suggest that our next highest governing authority is not a person, but a document. In the United States, our governmental leaders do not vow to preserve, protect, or defend a person, but to preserve, protect, and defend a document, the Constitution and the rule of law it represents. Today we choose to honor and grow even more appreciative of our Constitution and the painstaking efforts of not only those delegates who crafted this document 235 years ago, but for the Christian roots and the centuries of Western civilization that produced this document and the freedoms we enjoy as a result. With it, we also recognize our stewardship responsibility and the virtue that we are required to maintain if we are to keep this republic. I'm glad you are here today. Thank you for coming. And I want to thank John Malcolm for being our keynote speaker today. And a special thanks to Jeff Hunt and the incredible team at the Centennial Institute for bringing us a content worth celebrating and for understanding more fully. May God add his rich blessing to our time here this morning.
Good morning. My name is Jamie Erker. I'm the Director of Communications at the Centennial Institute, and it is my great pleasure to introduce our speaker this morning, John Malcolm. John Malcolm is the Vice President of the Institute for Constitutional Government, Director of the Meese Center for Legal and Judicial Studies, and the Ed Gilbertson and Sherry Lindbergh Gilbertson Senior Legal Fellow at the Heritage Foundation, where he writes on a variety of legal issues. An honors graduate from Columbia College and Harvard Law School, John has clerked for federal judges in the Northern District of Georgia and on the 11th Circuit Court of Appeals. For 10 years, John worked at the Department of Justice as an Assistant United States Attorney, an Associate Independent Counsel, and a Deputy Assistant Attorney General in the Criminal Division. John received numerous awards for his service, including the Director's Award for Superior Performance by an Assistant United States Attorney. From 2004 to 2009, he served as Executive Vice President and Director of Worldwide Anti-Piracy Operations for the Motion Picture Association. John then served as the Distinguished Practitioner in Residence at Pepperdine Law School. From 2010 to 2012, he was the General Counsel at the U.S. Commission on International Religious Freedom. John has also been actively involved in many charitable and civic organizations and was confirmed by the United States Senate in 2019 to serve on the Board of Directors of the Legal Services Corporation, the largest funder of civil legal aid for low-income Americans. I had the honor of meeting John when I interned for the Heritage Foundation myself in the fall of 2018, so I can say confidently that we are in for a great lecture celebrating our wonderful United States Constitution. Please join me in welcoming John Malcolm.
Those are tough remarks to follow. I thought those opening statements were inspiring for a moment. I thought that we were in the presence of Benjamin Franklin. And like an opening prayer, I think it really set the stage for the solemnity and celebratory nature of today's events. So although we are technically a day early, I want to wish you all a happy Constitution Day. I am really deeply honored that you have invited me as our inaugural speaker as we celebrate the 235th anniversary of the signing of the Constitution on September 17, 1787. George Washington, our first president, said, "The Constitution is the guide which I will never abandon." James Madison, our fourth president and often referred to as the father of the Constitution, said, "The happy union of these states is a wonder, their Constitution a miracle, their example the hope of liberty throughout the world." Calvin Coolidge, our 30th president, declared, "To live under the American Constitution is the greatest political privilege that was ever recorded to the human race," which was quite a remarkable statement for a man who was nicknamed Silent Cal. But what is it about the Constitution that inspires such loyalty and fulsome praise? And why does that praise seem to be in shorter supply these days? In fact, it is increasingly common to hear critics claim that our Constitution ought to be abolished, that it is outdated, broken, or racist. You were hearing that other campuses are not going to be celebrating Constitution Day. Indeed, there are many that are probably burning it or taking a red line and trying to change its words. In terms of the charges that it's outdated, broken, or racist, it is none of these things. And it is my aim to show you why it is as brilliant a foundation for government today as it was in 1788, the year it was ratified. Our Constitution is a remarkable document for many reasons. For starters, as you heard, it's the oldest national constitution still in use. It's also one of the shortest. It's only 4,543 words. Rather than drafting a lengthy document trying to capture every eventuality, the framers of our Constitution created a unique structure and articulated a set of principles that provided a framework for good governance. That structure and those principles have served us well, and in my opinion, continue to serve us well today. What makes them endure is that they are based in truths about power and human nature that are constant over time. That every person has inalienable rights. That power and liberty are always in tension. That men who wield power are likely to abuse it. And that the only way to restrain power is to divide it. One of the reasons why our Constitution is so remarkable is the quality and character of the men who drafted it. No other group of assembled political leaders was as attentive to the lessons of the past as the men who framed our Constitution. They had lived under a monarchy and understood the threats that were posed by an executive official who had too much power. They had also lived for several years under another governing document, the Articles of Confederation, which created a loose confederation of sovereign states and a very weak central government with no executive. That document proved to be woefully deficient in terms of creating a central government that could regulate commerce among the 13 sovereign states, negotiate with foreign nations, levy taxes to support troops in the field, and pay off the nation's war debts. The nation still faced many threats from the British, the French, from Spain, and Native American tribes. Moreover, any change to the document required the approval of all 13 states, which was not going to happen. In addition to their lived experience, the framers, particularly James Madison, studied political philosophers such as John Locke, Thomas Hobbes, Jean-Jacques Rousseau, and Charles Montesquieu, as well as the pros and cons of political systems throughout history. And they did all of this before they gathered in Philadelphia in 1787. Our Constitution was the product of intense intellectual thought about how best to form a government, and not the result of a long history of often trial and error, as was the case, for instance, in England with its unwritten constitution. The Constitution was the first charter of government in human history that was born of political philosophy and not political reality. Of the 39 men who had signed our other great founding document, the Declaration of Independence, 8 of them attended the Constitutional Convention, and 6 of them signed both documents. These men were not only the leading statesmen of their day, they were brave. The signers of the Declaration of Independence were, in a very real sense, traitors. They had each signed a document stating, quote, "We mutually pledge to each other our lives, our fortunes, and our sacred honor." If the British had won the war, as many, if not most people, thought they would, these men would have been hung for signing that document, and they knew it. One of the key attributes of the Constitution is that it was meant to complement the Declaration of Independence. The Declaration was a bill of particulars declaring the causes, which are referred to in the document as repeated injuries and usurpations, of a tyrannical monarch, which impelled the colonists to separate themselves from the crown. Most remarkably, that document declared that there were certain truths that were self-evident, specifically that all men are created equal, and that they had certain rights that came from God, that included life, liberty, and the pursuit of happiness. These were radical notions. These words were written by Englishmen. People in England were not considered equal. It was a highly stratified society. Rights didn't come from God. They came from the king. Moreover, the Declaration said that these rights were inalienable. Unlike privileges that could be conferred by a parliament or by a monarch and could just as easily be taken away, these were rights that could never be taken away. That document went further. It said a couple of very important and equally radical things about government. First, it said that governments are instituted among men for the sole purpose of securing these rights. And second, it said that governments derive their just powers from the consent of the governed. Thus, it is the Declaration of Independence that provided the philosophical basis for the notion that a government, any government, in order for it to exercise legitimate power over its people, it has to do so with their consent, not based on the whims and desires of a dictator or a hereditary monarch. While the Declaration of Independence defined the conditions of a free people, it is the Constitution that provided the framework for making sure that those conditions were secured and could flourish. And who is the sovereign in our country? Like the Declaration, the Constitution makes this clear up front. We, the people of the United States, are the sovereign. Not a king, not the government itself. It is we, the people. The Constitution, which was ratified by the people, sets forth the rules that are to govern public officials whom we choose to govern us. This was critical. The Federalist Papers are a series of 85 essays that were written by John Jay, Alexander Hamilton, and James Madison to support the ratification of the Constitution. As James Madison wrote in Federalist Paper number 51, if men were angels, no government would be necessary. If angels were to govern men, neither external nor internal controls on government would be necessary. In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. A dependence on the people is no doubt the primary control on the government, but experience has taught mankind the necessity of auxiliary precaution. Wise words. The consent of the governed also describes a regime in which people can govern themselves in accordance with their own religious, moral, and social values through voluntary associations, often referred to as civil society. And they can do so without interference from the government, unless the people themselves, through laws passed by their elected representatives that comply with the Constitution, say that the government can interfere. As Thomas Paine wrote, in America, the law is king. The rules set out in the Constitution establish in broad terms what actions various branches of government may take and what actions they may not take. And all public officials take an oath, which they sometimes forget, to uphold the Constitution, and that would include the limitations on their own power. When Madison arrived at Independence Hall, he had a plan that contained 3 fundamental structural elements that were ultimately included in the Constitution: separation of powers, checks and balances, and federalism, although each of these was modified from the original proposals that Madison put forth as through the ensuing discussions and debates at the convention itself. Under the framers' vision, power was not going to be concentrated, it was going to be shared. By diffusing power, the framers devised a structure of government that they hoped would be strong enough to ensure the nation's strength and prosperity, but without sufficient power to threaten the liberties of the people. It was all unprecedented and quite amazing. 3 separate branches of government at the federal level: the legislative branch, the executive branch, and the judicial branch. The framers were, of course, fearful about putting too much power in the hands of a single executive. They had, after all, just freed themselves from the dictates of serving under a king. They had also seen the problems, though, that ensued under the Articles of Confederation from a lack of a single executive. These were, as I said, dangerous times, and there was a general recognition that, as Alexander Hamilton said in Federalist No. 70, having a single executive would be, quote, conducive to energy. He continued, decision, activity, secrecy, and dispatch, all things that Hamilton thought were sorely needed, will generally characterize the proceedings of one man in a much more eminent degree than the proceedings of any greater number. He was right. And while many of those at the convention feared giving a single executive too much power, and while they took steps in the Constitution to check that power, they also took a great deal of comfort in knowing that the man who was presiding over the convention, George Washington, without question the most respected person in the country at the time, would no doubt serve as the nation's first president. One of those checks was the creation of an independent judiciary whose members were given life tenure, subject to good behavior, and a guarantee that their pay would not be reduced. This was done in order to insulate them from the undue influence of the 2 other overtly political branches of government. The legislative branch, another check on power on both the judiciary and the president, was split into 2 houses, the House of Representatives and the Senate. And as you heard, this is the result of a great compromise. One house with representation for all of the states, and the other with representation based on population. There were lots of other checks and balances built into the Constitution. All bills that appropriate taxpayer money has to begin in the House of Representatives, the body that is closest to people, where each representative represents a discrete area of the state and has to run for re-election every 2 years, as opposed to the senators, who represent the entire state and are elected every 6 years. The president negotiates treaties, but the Senate has to ratify them. The president submits the names of judicial and executive branch nominees, but they must be confirmed by the Senate. The House impeaches judges and executive branch officials by a majority vote, but they can't be removed until they are convicted by a 2/3 supermajority in the Senate. In order to pass a law, both houses of Congress have to agree to it, and the president has to sign it. The president can veto legislation, but then the House and the Senate can override that veto, again, by a 2/3 supermajority. Passing a law isn't easy. It isn't meant to be. That's a feature, not a bug. It encourages deliberation, compromise, and consensus building, and helps protect the interests of minorities who would otherwise be vulnerable to the tyranny of the majority, a phrase that was used by many of our founding fathers. While the president, as commander-in-chief, can initiate hostilities in appropriate circumstances to protect the country, only Congress can declare a war. Napoleon Bonaparte is thought to have said that an army marches on its stomach. And although a troop can order troops to march, or a president can order troops to march, that order won't be worth much if Congress doesn't supply the funds. George Washington knew this all too well. As he battled the British, he had to beg Congress to appropriate money to pay his hungry and thoroughly demoralized troops to prevent them from deserting. In general, the powers of the purse, which Congress controls, is a big check on presidential power. Only Congress can make laws, but only the president can execute those laws. Only judges can resolve cases or controversies, including lawsuits by individual citizens challenging the vast power of the federal government. What a remarkable thing. Article 2 vests the executive authority or executive power in the president. Article 3 vests the judicial power in the Supreme Court and in inferior courts. But only those legislative powers herein granted, that is to say, limited powers, are given to Congress in Article 1. Equally important to the constitutional design was the concept of federalism. As I mentioned, the Articles of Confederation proved inadequate to the task of establishing a cohesive, unified nation that could thrive and protect itself from the many dangers that we faced. On the other hand, the states cared deeply about their own independence, and the people cared deeply about the liberties that they enjoyed. At the Constitutional Convention, there was great concern that an overreaction to the inadequacies of the Articles of Confederation might produce a single, centralized, and all-powerful national government. The response to such fears was to create a government that was neither wholly federal nor wholly national, but a composite of the two. As I said a moment ago, Congress can exercise only those enumerated powers herein granted. In other words, the powers specifically set out in Article 1. In Federalist Number 45, Madison stated, quote, "The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. Whatever power is not given to Congress by we the people is reserved to the states and to the people." A half-century later, Alexis de Tocqueville, a French nobleman who spent 10 months traveling in the United States between 1831 and 1832, and who later wrote about what it is he'd seen and experienced in his magisterial book, Democracy in America, would praise federalism by stating that democracy in America is the result of the political vitality that was spawned by this incomplete national government. Today, some people think of federalism as a quaint term without any real meaning, and some even think of the term states' rights as code for racism. The institutional design, though, was to divide sovereignty between two different levels of political entities, the nation and the states. This would prevent an unhealthy concentration of power in a single centralized government. It would provide, as Madison said in Federalist Number 51, a double security to the rights of the people. The framers thought that federalism, along with the separation of powers, would be the best structure for protecting individual liberty and giving the people a voice in how they wished to be governed. I actually think that former Supreme Court Justice Anthony Kennedy put it quite well in a 2011 case in which he said, "Federalism secures the freedom of the individual. It allows states to respond, through the enactment of positive law, to the initiative of those who seek a voice in shaping the destiny of their own times, without having to rely solely upon the political processes that control a remote central power. The individual liberty secured by federalism is not simply derivative of the rights of the states." The framers also anticipated that the people might want to amend the Constitution so that it could be adapted to modern times based on their own lived experience. So they included Article 5 in the Constitution, which covers the amendment process. It is, of course, difficult to amend the Constitution, but it is not impossible. It's been done 27 times, and unlike the Articles of Confederation, it only takes 3/4 of the states, not all of them, to ratify an amendment. In fact, the Constitution was amended almost immediately after it was ratified. There was a great debate at the Constitutional Convention and during the ratification process in separate states about whether the structural limits and separation of powers that are contained in the Constitution would be sufficient to protect the liberties of the people, or whether a separate Bill of Rights was needed to protect those liberties. The so-called Federalists, which included James Madison, Alexander Hamilton, John Jay, the authors of the Federalist Papers, argued that the structural limitations on government were sufficient to protect individual liberties, while the Anti-Federalists, which included George Mason, George Clinton, and Patrick Henry, argued that a Bill of Rights was needed. 3 of the delegates to the convention, Mason, Edmund Randolph, and Elbridge Gerry, refused to sign the Constitution precisely because it lacked the safeguards that were ultimately included in the Bill of Rights. The Anti-Federalists won out in the end, and the last holdout states agreed to ratify the Constitution only with the explicit understanding that a Bill of Rights would be submitted in short order to the states for their consideration. The Bill of Rights, the name given to the first 10 amendments to the Constitution, were ratified in 1791, 3 years after the Constitution had been ratified. They ensured that certain rights retained by the people are off limits to the federal government. Some of these are outright prohibitions. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. The right of the people to keep and bear arms shall not be infringed. No person shall be compelled in any criminal case to be a witness against himself. Others are more nuanced or conditional. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. There's even a catch-all in the 9th Amendment, which says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. And the 10th Amendment provides that the powers not delegated to the United States, meaning those powers that were not given to Congress by we the people, nor prohibited by it to the states, there were a few prohibitions against state activities as well, are reserved to the states respectively or to the people. Does this mean that the Constitution was perfect? Absolutely not. The biggest flaw, of course, was the failure to abolish slavery. Sadly, this was a concession to the political reality of the time. Georgia and the 2 Carolinas threatened to leave the convention if the slave trade was banned. And as you heard, Rhode Island never sent a representative. If the Constitution had banned slavery, something that the Articles of Confederation had not done, only 9 of the 13 states would have been left to try to cobble together a nation, which likely would not have survived. It was nonetheless shameful and belied the majestic words in the Declaration of Independence that all men are created equal. And it was this failure, and the fact that several of the framers were slaveholders, that lead many people today to say that we should disavow the Constitution and dishonor the framers. I think that would be a bad mistake. So let me offer a few observations about slavery and the Constitution. The Constitution has been referred to by some as a pro-slavery document. I don't think that's accurate, although I would acknowledge that the Constitution did not outlaw slavery. For starters, the Constitution never mentions the words slave or slavery, and it never suggests that it guaranteed slave owners the right to import or even possess slaves on a permanent basis. Indeed, before the Constitution was ratified, Congress had enacted the Northwest Ordinance to govern new territories and expressly prohibited slavery in those territories. As Princeton University professor Sean Willans puts it, the Constitution initially tolerated the institution without authorizing it. That distinction, far from being a mere technicality, actually proved enormously consequential. After all, there has been one Constitution in our country that explicitly acknowledged the right to own slaves, and that was the Constitution of the Confederate States, which they adopted in March of 1861. In terms of our Constitution, there are 3 provisions, all the result of vigorous debate and compromise, that arguably protected the interests of slaveholders, at least for a time. They are the Fugitive Slave Clause, the Slave Trade Clause, and the 3/5 Clause, although again, none of them mentions the word slave. The Fugitive Slave Clause gave owners the right to seize enslaved persons, apprentices, and indentured servants who had escaped to free states. While certainly pernicious, this clause did not create a perpetual right to slavery. The Slave Trade Clause prohibited Congress from banning the importation of slaves until 1808 for 20 years. So what happened? In 1807, Congress passed a law which President Thomas Jefferson, himself a slaveholder, signed, banning the importation of slaves, effective January 1st, 1808. The very first day it could be banned. The one people talk about the most is the 3/5 clause. They somehow believe that this clause meant that slaves and black people in general were recognized as only having 60% or 66% of the rights or worth of white people. While perhaps understandable, this interpretation is wrong. The clause had nothing to do with the rights of black people, at least not directly. At the time the Constitution was ratified, free black men could vote in 6 states. The 3/5 clause did not increase or decrease that number. The 3/5 clause was about political power, not the rights of black people, although political power certainly had an impact on black people. Specifically, the 3/5 clause dealt with whether slaves would count as part of the census, which was significant. As is the case today, the census determines how many representatives each state has in Congress, in the House of Representatives, and also how many votes each state has in the Electoral College, which chooses the president. The northern delegates, who came from states that gave rights to some black residents and who wanted slavery banned, argued that representation should be based on free persons alone. They reasoned that if slaves didn't have any rights, they shouldn't be counted for purposes of determining representation in Congress. The southern states, on the other hand, wanted slaves to be, all the slaves, 100%, to be included in the count, even though the southern states had no intention whatsoever of giving slaves any rights at all. If the southern states had had their way, they would gain more seats in the House of Representatives, thereby making it harder to pass abolitionist legislation. And they would also gain seats in the Electoral College, making it more likely that they could elect a president who favored their views. Instead of settling on an all or none representation for slaves, the delegates agreed on the 3/5 count, a compromise which effectively increased the representation, at least partially, of the southern states in Congress and in the Electoral College, but also increased proportionally the amount of taxes that they would have to pay. Frederick Douglass, a former slave and the foremost black abolitionist of his day, called the Constitution a glorious liberty document. Nonetheless, it took a bloody civil war, the ratification of the 13th, 14th, and 15th Amendments, and decades of struggle, which continue to some extent to this day, to address the slavery issue and the rights of black people. There have been other changes, too, to our Constitution that have also altered the vision of the framers and how separation of power operates in the real world. Some of these changes were accomplished through the Article 5 amendment process. For example, the 17th Amendment now provides for the direct election of senators. This means that senators are no longer beholden on state legislators for their jobs, and therefore they no longer need to pay much attention to whether or not their actions impinge on the state's power, just so long as the people of the state continue to elect them. We ratified the 14th Amendment, which has led to the application of many of the prohibitions that originally applied only to Congress, also being applied to the states. Amending the Constitution for good or ill through the Article 5 process is entirely legitimate. Other de facto amendments have been accomplished through what, to my mind, is a less legitimate way, which gets us to the question of how to interpret the Constitution. There are those like myself who believe that originalism is the only legitimate mode of interpreting the Constitution. After all, if the Constitution does not have a fixed meaning, why bother to include a provision about how to amend it? There are other so-called living constitutionalists who feel quite differently. Originalism, by the way, contrary to claims made by some living originalists, is not some newfangled notion thought up by conservatives. Judges routinely attempted to determine the original public meaning of the Constitution, that is, until the Progressive era in the early 20th century, when all of a sudden this approach to judging proved inconvenient to those who came to power who had a radically different vision of what the role of government ought to be in our lives. The progressives believed, and still believe, that the people cannot be trusted to govern themselves well, and that good government can only be delivered by experts. They believe that the checks and balances and separation of powers in the Constitution are no longer suited to the needs of a modern society, and they were in fact proving to be an obstacle to good government. They believe that judges should be free to import their own beliefs and political preferences when interpreting the Constitution, and not bother with the constraints that originalism imposes on them. Progressive legal academics, the so-called legal realists, began teaching in law schools that judges have always made law rather than interpreted law, and that this was a good thing. In the early 1970s, Robert Bork was one of the first to remark that judges appeared to have lost their way. Contrary to what the legal realists were saying, Bork argued that it was possible for judges, quote, to take from the document rather specific values that text or history show the framers actually to have intended, and which are capable of being translated into principled rules. Several years later, Ed Meese, who was the 75th Attorney General under President Ronald Reagan and the namesake of the center that I directed, Heritage, started a firestorm when he gave a speech in 1985 at the annual convention of the American Bar Association, in which he spoke about a jurisprudence of original intent. Meese said the following: "What then should a constitutional jurisprudence actually be? It should be a jurisprudence of original intention. By seeking to judge policies in light of principles, rather than remold principles in light of policies, the court could avoid both the charge of incoherence and the charge of being either too conservative or too liberal. A jurisprudence seriously aimed at the explication of original intention would produce defensible principles of government that would not be tainted by ideological predilection. This belief in the jurisprudence of original intention also reflects a deeply rooted commitment to the idea of democracy. The Constitution represents the consent of the governed to the structures and powers of the government. The Constitution is the fundamental will of the people, and that is why it is fundamental law. A Constitution that is viewed as only what the judge says it is no longer a Constitution in the true sense. Those who framed the Constitution chose their words carefully. They debated at great length the most minute points. The language they chose meant something. It is incumbent upon the court to determine what that meaning was." The issue actually might have died there, except that Supreme Court Justice William Brennan felt compelled to respond. I'm grateful he did. In his speech at Georgetown Law School, Brennan declared that a judicial philosophy of original intention was the height of arrogance, and that it was impossible to discern what the framers would have intended when confronted with a case in the modern era. He stated, "We current justices read the Constitution in the only way that we can, as 20th century Americans. The ultimate question must be, what do the words of the text mean in our time? For the genius of the Constitution rests not in any static meaning it might have had in the world that is dead and gone, but in the adaptability of its great principles to cope with current problems and current needs." Now, Mises' critics, including Justice Brennan, did have a good point. How were judges to divine the intent of the framers themselves? The delegates to the Constitutional Convention, after all, were not unanimous in their views. At this point, Justice Antonin Scalia stepped into this intellectual debate and stated that rather than focusing on the original intent of the framers, the focus should be on the original public meaning of the Constitution. That is the meaning that was ascribed to those words and phrases by those Americans who drafted, considered, and after much debate, ultimately ratified the language. The debate between originalists and living constitutionalists continues to this day. In my view, living constitutionalism breeds judicial activism, which is a real problem. Too many judges treat the words in the Constitution as though they were empty vessels in which they could pour in whatever meaning they want. The left, which has included many liberal judges and Supreme Court justices, doesn't like the concept of a limited government. So they interpret Congress's power to regulate commerce among the several states to mean that Congress can regulate essentially any commercial activity, however minor or local, that occurs wholly within one state. They interpret Congress's power to provide for the general welfare to mean that Congress can tax us and spend money on virtually any project, even if it only serves one state or town and not the public at large. They interpret the Fifth Amendment, which provides that private property can be taken for a public use so long as just compensation is paid, to mean that the government can seize property and turn it over to a private developer if they think that at the end of the day there may be some public benefit in doing so. New rights, which appear nowhere in the Constitution and which are not a part of our nation's history, such as the right to same-sex marriage and a right to an abortion, are created out of whole cloth. After all, why bother going through the arduous and often fruitless effort to pass a law or amend the Constitution using the Article 5 process when you can find an activist federal judge who will simply declare that the objective that you are seeking to accomplish is a constitutional right, albeit one that had remained hidden ever since the time of our founding? The left often goes further, arguing that some of these unenumerated rights should prevail over rights that are actually explicitly included in the Constitution. They argue, for example, that a gay couple that wants to marry should be able to force a Christian baker to bake them a custom wedding cake celebrating their union, even if doing so would violate the tenets of the baker's sincerely held religious beliefs, thereby interfering in his right to freely exercise his religious beliefs, which is a right that is explicitly guaranteed in the First Amendment. They think that their civil rights should trump his constitutional rights. That's the wrong way to look at it. These are just a few examples. I could cite many more. Mind you, I will readily concede that originalism is not always easy to do in practice. Does the First Amendment's free speech clause mean that the legislature couldn't pass a law prohibiting from me walking up to you and saying, your money or your life? Does the Second Amendment prohibition against infringing on my right to keep and bear arms mean all arms or only some? Is it an absolute prohibition, or can the right be infringed under certain circumstances? Originalists don't always agree on the answers to these questions. Trying to discern the meaning of the Constitution isn't always easy, to be sure, but it does not require a judge to hold a seance or call the psychic hotline. It requires judges to look at dictionaries and other writings at the time and to consider how those words and phrases interact with other words and phrases in the document itself. And while it is true that the Constitution may be applied to new phenomenon that did not exist at the time, the words of the Constitution have not changed. Put me squarely in the camp with Scalia, Mies, Bork, and others. The Constitution is not a living document, but it is meant to be an enduring document. As Judge Bork once said, a judge who looks beyond the text of the Constitution when attempting to interpret it looks inside himself and nowhere else. A judge who does that is not looking at the document as it was understood by we the people, the ones who adopted it in the first place and provided the rules of the road by which we consent to be governed. If the people really want to amend the Constitution for some reason, there is, in my opinion, only one legitimate way to do it, and that is through the Article 5 process. It's not easy to do, but that's why it's there. Effectively amending the Constitution by judicial fiat is arrogant and undemocratic, to say the least. Judges have not been empowered to make stuff up as they go along. I realize it may be very tempting for a life-tenured judge to sit on a bench and to pretend to be Solomon, reaching results that he likes, even if the law doesn't allow it. Tempting though it may be, judges should faithfully apply the law and interpret the Constitution as it was understood by those who ratified it. These issues are currently being debated in a very public way, since the Supreme Court now has, for the first time in my lifetime, a majority of committed originalists. Their approach, trying to discern the original public meaning of the document and looking to the nation's historical traditions that existed at the time those provisions were ratified, were certainly evident this past term in many cases. It was evident, for example, in Dobbs versus Jackson Women's Health Organization, in which the court overturned Roe versus Wade and returned the controversial issue of abortion back to the people and their elected representatives. And it was evident in New York State and Rifle and Pistol Association versus Bruin, in which the court reaffirmed that law-abiding citizens who pass a background check have a fundamental right to keep and bear arms inside and outside their homes for self-protection. I could cite other examples. There are, of course, many on the left who don't like these results. One particularly disturbed individual attempted to assassinate Justice Brett Kavanaugh following an unprecedented leak of a draft opinion in the Dobbs case. Others have attacked the legitimacy of the court. Since the court will no longer read their progressive vision into the Constitution, it must be delegitimized, or at least restructured. They have proposed measures such as court packing, jurisdiction stripping, and term limits for Supreme Court justices in an attempt to manipulate the judiciary, hoping that it will produce decisions that satisfy their particular political agenda. While such measures do not pose a threat of physical harm to the justices, I do believe that these efforts pose an extreme threat to the independence of the judiciary. The justices of the Supreme Court are not partisans in robes. They are not there to win popularity contests. Indeed, there are several provisions in the Constitution which they have sworn to uphold, which are decidedly anti-majoritarian. Justice Sandra Day O'Connor, I think, put this quite well when she said, put simply, judges must be accountable to the public for their constitutional role of applying the law fairly and impartially. Judicial accountability, however, is a concept that is frequently misunderstood at best and abused at worst. It has become a rallying cry for those who want, in reality, to dictate substantive judicial outcomes. This effort by activists to have the two overtly political branches of government alter the structure of the one branch of government that is supposed to be independent from political influence is a very dangerous thing. As Alexander Hamilton stated in Federalist Number 78, though individual oppression may now and then proceed from the courts of justice, the general liberty of the people can never be endangered from that order. I mean, so long as the judiciary remains truly distinct from both the legislature and the executive. For I agree that there is no liberty if the power of judging be not separated from the legislative and executive powers. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. All judges, including Supreme Court justices, are there to interpret the Constitution, our Constitution, the very document that has helped to preserve our liberties while enabling our country to endure, adapt, and improve for 235 years. And for that, I will celebrate its birthday. And to those of you who think that there are more rights that ought to be in the Constitution, I will close with a quote from one of our founding fathers, Benjamin Franklin, who said, "The U.S. Constitution doesn't guarantee happiness, only the pursuit of it. You have to catch up with it yourself." Thank you again for inviting me, and I look forward to your questions.
I'm Dr. Tom Copeland, Professor of Politics here at CCU and Director of Research for Centennial Institute. We have a couple minutes for questions. We don't have extra mics, so if you would allow me to call on you and then speak very clearly and make sure that there is a question in your question. Thanks. Yes, sir.
What do you make of Adrian Vermeule's common good constitutionalism? You might have to briefly explain.
Yeah, no, well, so Adrian Vermeule is a professor at Harvard and has written a very controversial, but I think consequential book and series of articles in which he tries to go a third way, so living constitutional originalism, and he has put forward a proposal of common good constitutionalism, which basically says, well, I want to do justice to the way he would put it, that there are a lot of founding principles in our Constitution, and that judges should, when they interpret these phrases, be thinking about what would be in the interest of the common good of society, and that includes, on occasion, deferring to the administrative state, to the presidents, to Congress, in order to implement the common good. I think that movement had a lot of currency, certainly before this past Supreme Court term, because there were a lot of people that were very upset that originalism had not overturned Dobbs, that wasn't really an originalist case, but a textualist opinion had led to the Bostock case that Justice Gorsuch wrote. I was the author of the majority opinion. I think that issue has faded a little bit now in light of Dobbs. I am not, while I respect Adrian Vermeule, and I think that he has brought forth a lot of very important issues to consider about what were the understandings of the framers in terms of the analysis that he does at the time the Constitution was put forward. One, it really empowers the administrative state. Adrian Vermeule is a fan of the administrative state. I do not support empowering the administrative state. I'm in favor of disempowering the administrative state. And I also think that it is, at the end of the day, an attempt to do, I mean, to denigrate him, living constitutionalism, but with a conservative outcome, at least on some issues. Actually, on other issues like climate change, wouldn't be a conservative outcome. I think that judges have a tough enough time interpreting the Constitution rather than trying to read ancient Roman legal history and trying to determine what is indeed the common good. We don't have any real Solomons in our society today, and I doubt that any judges would adopt this mode of interpretation, could adopt this mode of interpretation, or that it would particularly lead to good results, in my opinion.
So you just had mentioned the administrative state. So how do we disempower? How do we rein in the administrative state? Because I think, from my perspective, that's the biggest problem. And how do you do it in a constitutional manner?
So I certainly could have talked about the administrative state, but my speech was long enough as it was, and I could talk for another very long period of time about the administrative state. So the administrative state is actually, it's a big behemoth that really does, in my view, upset the structure of the Constitution. In all of its manifestations, they promulgate regulations which have the effect of law that impose upon the states, so it affects federalism. Congress has effectively delegated lawmaking authority, lawmaking which has been vested in them, to administrative states by essentially saying, okay, we agree to pass a law that says, go out and do good with respect to whatever. You, administrative agency, go figure it out. And then these administrative agencies promulgate all of these laws, and they often then enforce those laws, including through administrative tribunals. And the Supreme Court has, through various deference doctrines, that probably were begun with good intentions, has ended up saying, well, if an agency interprets a law and is challenged, we, the judges, we're not going to look at it and say, as Chief Justice John Marshall said, that it is our province to determine what the law is. We will, even if we think this administrative agency has got it wrong, we will defer to the interpretation given to that administrative agency, so long as it is not unreasonable, an unreasonable interpretation of the implementing law. So in that sense, the progressives have indeed implemented the society that they envisioned at the time of Woodrow Wilson. The Supreme Court has started to nip at this and has done so in a variety of ways. One, there was a case that said that essentially administrative agencies could interpret their own regulations, and they would defer to those regulations so long as they were a reasonable interpretation of the statute. The Supreme Court a couple of terms ago in the Kaiser v. Wilkie case tightened that. and has made it easier to challenge interpretations of regulations by administrative agencies. There are a lot of challenges to the Chevron doctrine, which is the doctrine that says that they can interpret statutes and that judges should defer to those interpretations so long as it's a reasonable interpretation of the statute. A majority of the justices, although they haven't had a case in which they've hung their hat on this peg, have said that it may be time to revive what's known as the non-delegation doctrine, which says that essentially once Congress is delegated lawmaking authority, it cannot wholesale delegate that or subdelegate that to administrative agencies. So there's been some interest in reviving that doctrine. And then last year, in a series of cases, the vaccine mandate case, overturning the CDC's eviction moratorium, there were a couple of other instances, invoked what they're now calling the major questions doctrine, which essentially says that when an administrative agency issues a ruling that fits a little bit within its purview, but goes way outside of its purview, and ends up effectively setting a national policy, that if Congress wants to give an agency that kind of authority for a major question, it must do so very, very clearly, and if not, the agency will not be permitted to do that. It harkens back to an opinion that Justice Scalia wrote a number of years ago, in which he said basically, Congress does not hide elephants in mouse holes. If it means to give an administrative agency that kind of authority, it has to do so explicitly. So President Trump, as a matter of politics, did a lot to rein in the administrative state. The Supreme Court is now, I think, taking a very serious look at the power of the administrative state, but that's a brutal battle that's going to be waged for quite some time.
Was there an EPA ruling?
Yes, there was the EPA climate change was the third case that I was referring to. Yes, you had the vaccine mandate case, the CDC eviction moratorium, and West Virginia versus EPA. That was the case. Yeah.
Can you tell us a little bit about your work at the Heritage Foundation?
Oh, sure. So I've been there now for a little over 10 years. We do a lot to help the conservative legal movement, in addition to our own scholarship, speeches, public events, writings that we do, media that we do. So if there's a legal issue out there, we will comment on it. We also help a lot of the groups that litigate these cases behind the scenes. We will arrange, we have off-the-record invitation-only events with them in which we discuss strategy. We don't file amicus briefs or briefs on behalf of the Heritage Foundation, but we will help coordinate lots of other groups to file amicus curiae, friend of the court groups, to support litigation efforts by our allies. And we also have a very robust and quite good moot court program that we will do for people who are preparing for Supreme Court arguments and occasionally in the lower courts. And then we do a lot of public education. So a number of you picked up this booklet, The Essential Constitution. That is a booklet that we put out last year to help improve understanding of the Constitution and first principles. We're going to have one teaser. We're going to have one that comes out this year called The Essential Second Amendment. So look for that. You call.
Okay. What is your opinion of the lawlessness in our country now, potentially making the judiciary sort of irrelevant down the road? Judge Kavanaugh, I think in general the Supreme Court had people protesting in front of Supreme Court justices' houses and whatnot, intimidating them, harassing them. The increase in violence in the country, what do they call them, attorney generals, turning criminals loose before it ever gets to the judiciary. Do you have any thoughts about how serious that is and how it ends up?
Well, the current lawlessness in our country is it's a broad area. There's a lot of different ways in which I could talk about that. Certainly the threats to the judiciary are real. The protests outside the conservative justices' homes, obviously one of them wanted to commit violence. The guy who hid outside of Justice Kavanaugh's home wanted to kill him. And the non-prosecution of those people sends a message. There's lawlessness that's, of course, occurring across the country. We have problems with fentanyl and gun violence from gang members and some disturbed individuals, most of whom, by the way, get their guns on the black market. They don't get them legitimately. And you have, in certain select areas, what we refer to as rogue prosecutors, others refer to as progressive prosecutors, who have, and I've in the past supported some criminal justice reform measures, including, for instance, the First Step Act that President Trump signed, but they had a radical vision of law enforcement, and they are the tip of the spear. No case goes to court unless prosecutor, or criminal case goes to court unless prosecutor brings it, and they are implementing some very dangerous policies about releasing people, about no cash bail provisions, about effectively excising various criminal provisions from their state codes, in some cases federal code. It is deeply, deeply troubling. We have as you all know, a very, very divided country, and we're going to continue to fight on these issues. You're seeing this morning, right? So we have effectively, in my view, a non-enforcement policy at our southern border. And so there are hundreds, if not thousands, of people pouring into the border states every day with really no check on them whatsoever. And the left is perfectly happy with that and accuses anybody who thinks it's the bad thing of being xenophobes and racists and bigots. But God forbid if you send 20 of them, as just happened from Florida up to Martha's Vineyard, they're positively apoplectic. So we are having these debates where we are a divided country. I mean, another thing that is very, to me, it's a sign of lawlessness, although it literally doesn't result in violence, is the degree to which we are demonizing people who do not agree with us. The cancel culture on college campuses and within businesses, the political rhetoric that is going on to some degree on both sides of the political aisle, saying, we can't have a civil debate. You just need to be canceled because your words are violence and you are a horrific individual who needs to be silenced. Or if you engage in the political process or potentially get a subpoena or be prosecuted for your political beliefs, that is also very dangerous. It may not be violent lawlessness, but it's lawlessness nonetheless, in my opinion, or an abuse of authority.
Yes, having established the state legislature's Article 5 caucus about 10 years ago, I'm a strong advocate for federalism. And in light of that, I'd like you to expand a little bit on the various mechanisms for amending the Constitution in Article 5 and get your perspective on it. Thank you.
Sure. So Article 5 talks, well, there's the de facto method of amending the Constitution, which is an active judiciary that I consider illegitimate. Article 5 has really two different ways of amending the Constitution, only one of which has been utilized, except for the original ratification of the Constitution, which is you can either have both houses of Congress, 2/3 of both houses of Congress, propose an amendment that is then sent to the states for ratification and requires 3/4 of the states to ratify it. Or the states themselves can do what this gentleman has supported, which is call for a convention of the states. And there is some dispute about whether the states can get together and say, we want to call a convention of the states, and it also has to be 2/3 of the states, for a very specific purpose, which is to have, whatever, do away with the Electoral College, or do away with the constitutional right to same-sex marriage. Pick your right or your left amendment if you want. So there are those who believe you can have a constitutional convention or a convention of the states for to consider one amendment. There are others who say that the Article 5 process says you can have a convention of the states, as the Constitution says, to consider amendments, and that you can't have a closed convention. You can call a convention to be sure, but then it has to be opened up to anybody who wants to put forward an amendment. But if you have 2/3 of the states call for a convention of the states, and if at the end of that convention of the states, 2/3 of the states, which I think is 64 states, 34 states, 34 states call for a particular amendment to be submitted to the states, and it will be, and it has to be ratified by 3/4 of the states, which I believe is 36 states, before it can go into the Constitution. The beauty of doing that is you might want to, for instance, propose a constitutional amendment that reins in the powers of Congress. Congress is highly unlikely to propose an amendment that would constrain its own power. So this is another important check and balance that was built into the Constitution. If the people do not like the way Congress is controlling the amendment process, they have an ability to bypass the amendment process. I would also add, by the way, that another check that I could have mentioned on the presidency is that whether you use either method of amending the Constitution, the president has no role in that process. That is the process that is controlled by Congress, if you use the first method of ratification, and by the people, and those two bodies alone.
I have a question.
Yes? Take your two hands up. Okay, go ahead.
Well, it's not really a question.
Malcolm, hi.
Yes. Thank you so much for explaining Article 1, Section 2 of the 35th clause, because most African American people, if you all don't know about that, we do interpret that wrong, and understanding that the black people were only worth at that time 3/5 of a person. But if that law has not, if that bill hasn't, how do you say it hasn't been passed? The southern states, which was the Democrats at the time, would not have been able, the House would not have been able to pass the abolitionist legislation because of it. I really appreciate you taking the time to explain that.
Thank you. So I got time, so this is you control how many you at the time, and my flight's not till 1 something.
What role would you say that Christian faith plays in our nation honoring the Constitution? And can we expect people to respect the Bill of Rights if they don't believe that those rights are unalienable from Christ?
Okay, I'm not sure well, look, I think that you know better than most people that religious people of faith are under attack. They're certainly under attack in our society. If you are willing to provide services to a gay couple or a transgender individual, that you will not come out and provide those services to them when they wish to marry. And so, look, Jack Phillips, the baker here in Colorado, a masterpiece cake shop, perfectly happy to sell a non-custom cake to a gay couple for their wedding. Perfectly happy to provide a custom cake to a gay couple to celebrate anything that they wish to celebrate except for their wedding. He is not allowed to exercise his beliefs, and his views are not respected, even though that same couple could walk probably 3 or 4 blocks away to another baker and get a custom cake made by that baker. Indeed, that baker might even have a commercial advantage by being able to say, we make custom cakes for everyone under all occasions, and hanging out a rainbow flag. The live and let live philosophy is dead on the left, and nowhere is that more evident than when it comes to people practicing their faith. Even groups like, when Justice Scalia and the Supreme Court came out with this really terrible decision in Employment Division versus Smith, which essentially says that any law, so long as it's neutral on its face and generally applicable, can be applied to everybody, and it doesn't raise free exercise concern. Once that opinion came out, Congress overwhelmingly passed, and President Clinton signed into law the Religious Freedom Restoration Act. The ACLU were vocal supporters of the Religious Freedom Restoration Act. They were very happy to go out and file cases if somebody wanted to prevent a Jew from wearing a yarmulke, or a Muslim from getting halal beef, or having the right to have a prayer rug and do his prayers. But all of a sudden, when it came to Christians wanting to do something that they thought was unfair to one of their favored groups, that those principles began. And they now are totally opposed to things like the Religious Freedom Restoration Act. I think that this Supreme Court is fairly robust in terms of protecting the free exercise clause. You saw that last term in 3 cases that I can think of. One of them involved a condemned man who wanted to have his pastor lay hands on him and recite a prayer as he was exiting this world. Another was the Carson v. Macon case, which was a tuition assistance program out of Maine that would go to secular private schools. And another, of course, was the Coach Kennedy case, the Bremerton case, in which he is now allowed to, after games, go say a silent prayer on a 50-yard line and exercise his faith in that school. There are disappointments along the way. The Supreme Court just declined yesterday to put a stay in place from a lawsuit in which a group of gay students at Yeshiva University want the university to recognize their club and to promote their events, even though the university says that this is not in keeping with their interpretation of Torah, which they try to impart to all students. So it is an ongoing struggle, but look, in general, people are, in our society, they don't go to church as often, they care less about religion, and they have adopted a lot of secular and political causes as their religions, and so it's going to be a constant struggle. But, I'll put my money on it. Thank you.
Well, it sounds like Mr. Malcolm will be available for a little while here after we're finished. So I just want to wrap with something. One of CCU's strategic priorities is to train students to take positions of significant leadership in all kinds of contexts across the country, including government. And so we have programs here at CCU teaching politics and public policy and criminal justice. We have a pre-law program and a fantastic nationally competitive moot court program, by the way. And we're proud of what we're doing. Our alumni go on to positions of leadership in Colorado politics, in other states, in Washington, D.C., and we're very proud of the work that we're doing. If you are interested in what our students are like, there are about 24 of them here. Many of them are here at tables closer to the windows, but if you've not had a chance to actually meet, if you're a visitor to campus and you've not talked with our students, I invite you to get acquainted with them. This summer at the Western Conservative Summit, we're really excited to announce a new endowed scholarship for public policy here at CCU. And this is going to enable us going forward to provide scholarships to students who plan to study and go into public policy, to be leaders in these positions who hold to the Constitution. And this is an exciting new program. If you are interested in finding more out about that, talk to Jeff Hunt, President McTavish, Dr. Janet Black, our Vice President of Academic Affairs. If you'd be interested in knowing more about that and how you could help make sure that we're training the next generation of leaders to take these kinds of positions, please speak to any of us about that. Thank you again for coming. Go with God.
Same to you. Same to you.